Hi, my name is David Lopez, co-dean of Rutgers Law School in Newark, New Jersey, and this is The Power of Attorney. Today we are very privileged to be able to highlight a couple of our wonderful scholars and distinguished professors working on issues of criminal law at Rutgers Law School. With us we have Professor Stuart Green, welcome.
Thank you.
And Professor Vera Bergelson.
Thank you.
We're going to get into some very interesting and I think timely issues. We're going to talk about Professor Green's recent book, Criminalizing Sex, a United Liberal Theory, and we're going to grapple with some of the moral puzzles of criminal law, the title of one of Professor Bergelson's classes. But before we get into it, one of the privileges about this particular interview is that Professors Bergelson and Green are very good friends and they know each other pretty well. So I will start out by letting them introduce each other. Professor Bergelson, what can you tell me about Professor Green?
Well, I've known Professor Green for at least 15 years, I would say. We first met when he was not yet part of the Rutgers faculty, and it was one of my first conferences in Louisiana where he taught. And I was actually a commentator on his paper about bribery. That's how we met each other, and since then our paths have often crossed professionally, and I've always admired Professor Green's work. I have not always agreed with everything he says, but that only adds to the pleasure of working in the same field. And the courses that he teaches, including the seminars on the theory of criminal law and white-collar crime and sexual crimes, the topic of his current book, are very popular and very well respected.
Wonderful. Professor Green, payback time.
Well, I do well remember Vera coming to our conference in Baton Rouge, Louisiana, and we were excited to have her, and she did a great job. But the next significant moment that I remember with Vera is when one day I got an email from her, and it was in July or August, and she asked me if I was interested in possibly coming to Rutgers to talk about the possibility of joining the faculty. And I was thrilled to get that email and to talk to her on the phone, and I think she really, more than anyone, is responsible for bringing me here. So it's fantastic to have her as a colleague.
Oh, that's wonderful. Now, why don't you talk a little bit about your path to Rutgers Law School? You mentioned that Professor Bergelson was very instrumental in that, but talk a little bit about your background and your interest in criminal law.
Well, I grew up in Philadelphia. I went off to college at Tufts University, was kind of an indifferent student in high school, but found in the first semester of college what would be kind of my life's path in doing philosophy, and especially moral philosophy. After college, I worked in the publishing industry for a couple of years in New York City. Then I decided to go to law school and really always enjoyed the criminal law courses. Went off to clerk for a year, practiced for a few years, but always found myself drawn back to questions in criminal law, which seemed to be a very fertile ground for thinking about some of the moral questions that had originally drawn me to philosophy as an undergraduate many years before. So I was lucky to get a job teaching first at LSU. Louisiana is a rather unusual place in the United States. It's a hybrid mixed jurisdiction, meaning that not only does its law reflect the English common law that is used everywhere else in the United States, but also reflects the civil law originally from France and throughout much of the rest of the world. And so I had an opportunity to pursue my interest in comparative law at LSU as well, which has allowed me to travel around the world and talk to other people in my field with great pleasure and profit. Not profit like money profit, but intellectual profit.
But we pay you okay.
Absolutely.
And you both are very adept at using the comparative approach. Why don't you talk about your path to Rutgers Law School, Professor Bergelson? I know it's an interesting story. I remember talking about it over dinner.
I was born and grew up in Moscow, Russia, and both my undergraduate degree and my PhD were in the field of Slavic literatures. And I think that was the first step in the direction of criminal law and philosophy, because I was always interested in human emotions, in drama, in moral dilemmas, and what can combine them more than either literature like Dostoevsky or criminal law that involves all those moral choices and human drama. So I came here in 1990 and very soon discovered that my degrees were useless and I had to do something else. So I decided to go back to school, and law school was a natural choice. I was fortunate to be at the University of Pennsylvania, which both at that time and now was a fantastic place for criminal law theory. And my teachers, Michael Moore, Heidi Hurd, Leo Katz, Stephen Morse, they all contributed to my interest in criminal law theory. So then I also practiced for a few years, paid back my school loans, and the moment I did that, I wanted to be back to academia. And so that's how I came here. And I'm very fortunate that I could start teaching in the area of criminal law because it was always my main interest, and my first article published after law school was actually a transition from literatures to criminal law. It was retrial of Rodion Raskolnikov under the Model Penal Code.
And you want to tell the listeners who that is?
Sure, it's the protagonist of Crime and Punishment by Dostoevsky.
Wonderful. Now talk a little bit about Rutgers Law School as a research institution, and talk also a little bit about really the importance of academic freedom. I think both of you are working in an area that is very, very complicated and potentially, I think, ripe for controversy. Let me know what your experience has been at Rutgers as a research institution.
Oh, I always loved it here, and it was a great place to explore ideas, and both the faculty and students were always receptive. Students just loved provocative ideas. They loved being challenged. And since both Stuart and I write in the areas that are rather provocative and involve sex and moral choices, that's the topic that is always fascinating both to students and faculty. So my experience has been very positive.
And talk about the importance of academic freedom as you delve into some of these provocative areas.
Well, it's hard to overestimate how important it is to be able to write and take positions that may not be popular. And I think I've never felt at any time that my job was at risk if I wrote something unpopular. I think that's absolutely essential to being a scholar, being a teacher, being a student in higher education.
Has there ever been a time when your work generated particularly sharp feedback from either other scholars or from the public?
Well, it's funny that would that my articles were as widely read to generate lots of controversy. Certainly, I have colleagues who disagree vehemently with my positions, but most of them are pretty civil in terms of their approach. I think the times when I've written a few op-ed pieces here and there are, I've had the experience of getting sort of immediate feedback, sometimes within the very day that the piece appears, sometimes from all over the country, about pieces that, in one way or another manage to provoke or pique people's interest. So I think it's important for scholars to write pieces in the popular press, and to find time to do that, because sometimes you get much more reaction than you get with a more ponderous article or book that doesn't get as many readers. Now you want specifics.
Yeah, if either of you have any specific examples that you think the listeners might find interesting.
Well, I did have a piece a couple of years ago in which I announced to the world that I wasn't going to have my students use laptops anymore in class or electronic devices, and that got pretty wide play. A lot of people disagreed that was a good pedagogical approach. But I think it's fair to say that my students have, while initially sort of pushing back on the idea of not being able to bring their beloved devices into the classroom, usually have to concede by the end of the semester that it's actually a pretty good way to remove some of the distractions that they're used to. So I consider it a success.
Oh, okay. Professor Bergelson, anything?
Well, usually my articles are mostly read by my colleagues and scholars, but once I had an interesting experience of wide discussion of my paper by people who are pretty far from legal academia. I just published a paper about consent to physical harm, and went away on vacation. And when I came back, my mailbox was filled with various letters, usually appreciative, from members mostly of BDSM, bondage, domination, sadomasochism community, which appreciated my liberal approach to individual autonomy, and also wanted to discuss my paper on their web pages, which initially I said, oh, sure, of course, you can cite it. And then I thought maybe I should first check that web page, which I did, and it was somewhat of a revelation. It was quite interesting. The audience was obviously involved in discussion, and on the left-hand side of the page there were various devices that people could purchase for their personal use. On the right side of the web page there was a discussion consisting of hundreds of comments of my article, which I found very flattering.
And that's a really interesting story, and it's kind of a segue to, I think, the broader conversation about consent in criminal law. But before we jump into that discussion, I want you both to talk a little bit about your recent scholarship. Professor Green, you just are in the process of completing a book, and I know that you've been working diligently on it for many years. Do you want to talk about the book and really the process of writing it? What led you to write the book?
Well, I have for a long time now been working on what we call the special part of the criminal law, which is the part of the criminal law that consists of, it is the special part, but it consists of specific offenses, as opposed to general principles of punishment and why do we punish. So I've been sort of working my way through, and I had written a book on theft law, and I had written about white-collar offenses, and so I was kind of thinking about what would I do next, and then within the course of just a few months, I attended two different conferences, one actually here at Rutgers on the vice offenses, and another one I think at Villanova Law School, which was about the sexual assault and rape. And I went to these two conferences, and neither was an area where I had written very much, but somehow I ended up there. And what I found was that, although both conferences involved discussions about sex and the law, and the criminal law in particular, there was very little sort of common ground between the two conferences. None of the people who were at one conference were also at the other conference, and vice versa, except for me. And the conversation was very different at the two, and that struck me as kind of surprising and interesting that there would be these sort of two discrete parts of the sexual offense literature. So I started to think, well, maybe that would be a good project for the next book. How could I think about the non-consensual offenses that were being considered in the conference on rape and sexual assault, and connect that to a consideration of the consensual, or at least putatively consensual offenses that were being discussed at the other conference. And so I began to think, well, maybe there was a way to link them and to create a unified theory that would apply to the whole body of law.
And so your book is called Criminalizing Sex, a United
A
Liberal.
unified liberal theory. So the idea is to take certain principles that we could refer to as liberal principles, although someone could dispute whether those are the right principles. But the general principles are, first, that the law ought to protect people's right to be free from unwanted or at least non-consensual sexual contact. And that people have a duty not to infringe on other people's what we call negative sexual autonomy. And that when they do, that the state should step in and protect people whose right to sexual autonomy, to negative sexual autonomy are protected. That is the right not to be subjected to conduct that you don't want to be. But simultaneously, the law also has a responsibility to protect people in their right to engage in positive sexual acts. Those are acts that they wish to engage in, whether with other people on a voluntary basis in private or maybe by themselves. But those are things that the state should not try to regulate or certainly to criminalize. So on the one hand, those seem to be consistent principles, or at least not obviously inconsistent. And I think that's true at a fairly abstract level. But when you try to institutionalize them or implement them into law, then sometimes you run into conflicts where what looks like it might be non-consensual behavior actually has a consensual element, or that looks like consensual behavior might have a non-consensual element to it. So in the book, I try to go through in some detail a wide range of different offenses and say where the line should be drawn, or at least what questions we need to ask in trying to create a law that is internally consistent with those liberal principles.
And Professor Bergelson, you've also looked at the broad issue of consent. And I think at first blush that might seem like a simple concept. But as you start to drill down in your work, I think you've discovered that it's really not as simple as it seems at first blush.
No, it's certainly not simple. Usually we think about consent as a placeholder for human autonomy, a very important ability of an individual to waive his or her rights and to let people do something that otherwise they would not have the right to do. So normally, I have the right that people do not trespass on my property. I have the right that they do not take my things, that they do not touch me. But if I consent to all those things, they suddenly receive the power and liberty to do that. And in that sense, as Heidi Herd once said in her paper, consent is magical. It turns things that otherwise would be crimes into things that are absolutely morally neutral or even positive. But then, of course, the question is, what does it mean to say that someone consents? Is it something that happens in my head, or is it something that I express? And there are different theories about that. So, say, for instance, the old approach to sexual crimes was that if to be sexual assault or rape, the sexual intercourse has to happen by force and without consent. And without consent meant without the internal meaning, internal acquiescence by the victim. In more recent revisions, this legislature started revising the meaning of consent to explicitly mean something affirmative. It's not consent unless it is expressed. And so there are two theories of consent, expressive and attitudinal. That is already pretty complex. And my own experience with this concept was that once, many years ago, I was writing a paper about something else. It was about the relationship between the perpetrators and victims. And one portion of that paper was about consent, simply because consent of the victim seems to reduce or eliminate the responsibility of the perpetrator. And I thought that it would be very easy because I had strong liberal intuitions, and I felt that if it's consensual, it's right. And then what happened was that a German case was published, the case in which an individual published an ad on a special website seeking for a man who would want to be killed and eaten, and he found such man. And they met, they discussed, they both apparently were psychiatrically normal, even though probably they had lots of psychological issues. But and everything was videotaped, so everything happened the way they discussed, and that created a huge issue because, yes, it was consensual, and yes, it was awful. So my own intuitions went down the drain. I realized that I don't know what I feel anymore. So I finished that paper and decided that I should spend more time on just figuring out how I feel about consent. That's what I was doing for the next 10 years.
And on the way up here, I ran into one of your students in your moral puzzles in criminal law class, and she was talking about what I guess is known as the German cannibal case. And I guess this is sort of, really interesting case study in terms of the complexities of consent.
Oh, it is. And our last class, which was only a couple of days ago, was about consent to physical harm, which raises numerous issues, not just this awful case, as we know, but other cases, including assisted suicide, which is also consent to ultimate harm, or less serious, possibly issues of, but still important, of either college hazing, to what extent it is consensual, or other issues when people agree that someone else physically harms them. And the puzzle is that if they did all those things themselves, that would be outside of realm of criminal law. But if they give authorization to another person, and even when we're completely sure that that authorization was voluntary and informed and rational, that person who helps them to achieve that harm is criminally liable.
And of course, in the sex crimes context, these complexities have a particular resonance. And we're still trying to figure it out. So I think that, many of us are sort of accustomed to hearing in kind of popular conversation about so-called victimless crimes. And those crimes sort of are roughly defined as something like prostitution or pornography, where you don't have purportedly a victim, and where you have, in the case of prostitution, a consent between the parties, or in the case of pornography, where there isn't like the deprivation of consent. But it's really not that simple, right?
Right, it's not that simple at all. So to give another example, and another German case that comes to mind, is a famous case of a brother and sister who met as adults, or at least consummated the relationship as adults, and fell in love apparently, and got married, or at least were living together, and started having children. And they, of course, were engaged in incest. So the law has traditionally treated incest as a crime, even though at least some cases of incest are clearly consensual. And it appears that they were consensual in this case, although there's some ambiguity about it. Unfortunately for this couple, they had several children, and three of their four children had very severe birth defects. So the question was whether they could be prosecuted. They were prosecuted under German law, and they ultimately appealed their case to the European Court of Human Rights and said that their right to sexual choice had been abrogated. What's interesting about the case is that, it's an example, like prostitution, maybe like sadomasochistic behavior, that in one sense it seems consensual. It seems like the parties to it are agreeing to have this conduct, to engage in this conduct. But then sometimes once you begin to dig down a little bit more, you see that it is more complicated. So in the case of incest, many cases of incest, in fact, even though they may be, and I'm putting aside incest involving children, which is an entirely different phenomenon, But incest involving adults, often if you look into the history of the relationship, you'll see that it often began when one of the parties was a juvenile, or where there was a hierarchical relationship between the parties. Similarly, in the case of prostitution, liberals like to think that, well, prostitution should be legalized because it's a consensual relation, a consensual contract between the seller and the buyer. But if you look deeper, often you'll find that very often the sex worker has been coerced, or has been, in the worst cases, trafficked, or is under some kind of coercion or duress or economic duress, which causes them to go into the trade in the first place. And in the case of sadomasochism, again, it may be that once you look beneath the surface, you'll see that, in fact, some of this conduct is may be a part of domestic violence or other kinds of non-consensual behavior. So the difficulty is, how should the law be shaped in such a way that we can allow people to engage in truly consensual behavior, while at the same time creating rules that are going to protect people from the possibility of being subjected to non-consensual kinds of acts. And I think each of those putatively or ostensibly consensual forms of behavior raises exactly the same problem.
Is it useful to look to the law of contracts in terms of analyzing these questions? I know that Dean Chen, a very well-known contracts professor here at Rutgers, will teach about consent, but will also talk about duress and power disparities and fraud and misrepresentation and all of these other doctrines that really provide defenses to the argument that a contract was formed. How useful is it to sort of look at contract law in terms of understanding the concept of consent in the criminal law context?
Well, any analogy is useful to some extent. I would say that some of those relationships, to the extent they have the meeting of the minds and they're voluntary and rational, they may be helpful in understanding the nature of the sexual choices that we're talking about. But at the same time, I would not just reduce the complexity of, first of all, sexual relationship and criminal law just to contractual issues. Usually there are many more personal dynamics that have to be considered. But I wanted to add, if you don't mind, a couple of words about to our conversation about incest. It's just an example of legislative act which clearly aims to be helpful, but at the same time may produce some ridiculous results. A few years ago, we were all invited to comment on the sexual assault definitions and crimes in the New Jersey law, and to give our advice to New Jersey Law Revision Commission. So I did just that, and one of the provisions that I wanted the commission to revise involved incest, because what it seemed to say was that it would be sexual assault, which is a crime of the second degree punishable by 5 to 10 years, if a sexual act happens between two individuals, one of whom is between the ages of 16 and 18, and the two people are related to the third degree. And that...
What's the third degree?
Third degree is second cousin.
Okay.
And that was strange in New Jersey in particular, because New Jersey does not criminalize incest after the age of 18 at all. And also it allows first cousin marriages. And also the age of consent in New Jersey is 16. And also the age of legal marriage is 16. So two second cousins who can be legally married in New Jersey at the age of 17 at the same time are criminals. And I tried to point out this inconsistency, which was sort of taken into account in our conversations with the members of the commission. But when I looked recently at the current law, the provision was still there.
Do you know the rationale that they gave for the provision?
They didn't give much. That was the basic idea of trying to protect people from, particularly juvenile victims, from possible abuse and exploitation. So the reasons are usually good. The problem is that they are not always thought through. And as we know, in many jurisdictions, the definition of incest includes not only close relatives, but also adopted children, adoptive parents, which raises many questions about two children who were not even related, or possibly two adults who are related but grew up in completely different households.
You offered or you asked about the analogy to contract law, and another sort of important possible analogy is that both contract law and the law of sexual assault are concerned with capacity to consent. And so, the law requires different forms of capacity or different levels of capacity for different kinds of acts. So you need one form of capacity to enter into a contract, another form of capacity to enter into, say, a marriage, another form of capacity to write a will, another form of capacity to have a consensual sexual relationship. So we have lots of problems about what exactly constitutes adequate consent in the sexual context. For example, involving intoxication or developmental, intellectual deficits, or people who are sleeping or in some other way incapacitated. And we struggle a lot with that. I think perhaps even more than you do in the area of wills and trust and contracts. All of those areas of the law require some assessment of people's capacity to give what's essentially a form of consent. The difference is that in the criminal context, you're going to potentially put someone in prison. In the case of a contract or a will, I guess the worst possible consequence would be that you would invalidate the will or the contract.
And as someone who has litigated several sexual harassment cases, I'm really interested in how the concept of power and duress plays out in this conversation. I think the Me Too movement has really illustrated in many ways in the public consciousness the abuse of power in some of these, and I use the term loosely, relationships. What type of guidance would you have? What kind of analytical framework would you have for policymakers or the public in terms of thinking about issues of duress? Let me give you an example. Both of you talk about the whole concept of sex as deception and sex as fraud, or sex through fraud. And I thought that was extremely interesting and extremely complicated. And as I was reading both of your articles and your book on this, I wasn't quite sure where I came out. Do you guys want to talk about power and deception and fraud and all these other contractual principles and how they play out here?
Well, let me offer a little historical context, and then maybe Vera can pick up the ball from there. Until, say, the middle of the 20th century, in order to prove a rape case, you had to show that the defendant used force against the victim, and that the victim sometimes had to resist. And that's sort of where things stood. And then near the latter part of the 20th century, we had this really radical shift, the beginning of a radical shift in how we thought about rape law and sexual assault law. One of the real seminal figures in that area was Susan Estrich at Harvard Law School, who went on to be Mike Dukakis's campaign manager, and then she moved to Hollywood and hasn't been heard from since. But no, she's, I think, still a well-known
USC, UCLA.
Yeah. So Susan Estrich wrote a number of important books and articles on the subject, and one of the arguments that she made, or claims that she made, was she said, well, look, why do we give more credence to deception that's used in the realm of fraud, economic fraud? Why do we take that more seriously than we take in the case of rape and sexual contact? So she said if somebody lies in order to induce another to have sex, and the person otherwise wouldn't have agreed to it, but for the lie, then we should treat that as non-consensual, and because in this new way of thinking about rape and sexual assault, we now should view that as, if not rape, then at least a lesser form of sexual assault, because the argument being it's not really consensual if the consent was obtained pursuant to a misrepresentation. So that's fine as far as it goes, but once you really begin to think about what that implies, you realize that, well, lots of people use misrepresentation in the sexual context all the time. You could probably, go to, what's the name of the bar across the street? Put your tape recorder there and probably capture, I would guess, lots of people making misrepresentations about various manners, which may in some cases lead to perhaps sexual contact. The question is, and people may consent in cases where they otherwise wouldn't, but for the lie. So the question is whether when do we want to treat that as a crime? And traditionally, the common law was very, very restricted in what kinds of misrepresentations were sufficient to invalidate consent. Now I think we're moving in a direction where we are contemplating having a larger number of kinds of misrepresentations as a predicate for rape.
Or you could go to the Met and watch Don Giovanni and perhaps see several crimes being committed in the course of one opera, correct? Now, you write about this extensively, and you talk about the approach that the Israeli courts, and I think also the courts in the UK are taking on this. Do you want to talk about this and then sort of weigh in on these issues?
Sure. So basically, historically, as Stuart was saying, courts did not treat fraud or lies in sexual context as a predicate to a criminal conviction, except in very limited circumstances. So when the lie involved the nature of the act, say a woman thinks that she comes for a medical examination and the doctor does something completely different, that was rape. Or in many jurisdictions, when a woman thought she was having sex with her husband and someone else impersonated the husband. In many jurisdictions, that was viewed again as rape, but on the logic that otherwise it would have been adultery. And because the husband was held the exclusive entitlement to her sexual intimacy, that also was considered possibly as rape. Other kinds of lies were not viewed as criminal. And that started changing, and I just noticed that in the course of maybe several years in many countries, in Canada, UK, Israel, Germany, there were numerous cases that involved criminal prosecution of men, usually men except in the UK, I will talk about it, who lied about their age, about their ethnicity, about their national origin, religion, and they were prosecuted on various theories, usually sexual crime, sexual assault, or receiving benefit by fraud, as in Israel. And that kind of conduct didn't seem to be criminal only recently, and so I started exploring and trying to find where is this line in what Stuart was talking about, where is the line between lies that are sort of acceptable, lies about someone's weight or age, or someone wearing even high heels or mascara, which arguably is a lie because it makes you more attractive, or, as in one influential article, lies about, I went to Yale, if someone didn't go to Yale. What if all those lies, in fact, were material in making the decision to engage in sexual behavior? Should we say that these lies are criminal? Usually not, right? But then there are other lies, and those lies could be not only about the nature of the act, but also lies about the purpose of the act. Say a woman knows that she engages in sex, but she thinks it's necessary for her medical treatment. Or lies about something that is important during the sexual act. For example, wearing condom or using other protection or being free of the sexually transmitted diseases. Those lies clearly are important. So, and these lies are not lies like, oh, I went to Yale. So where do we draw the line? That's what I was interested in when I was writing my paper. And eventually I concluded that lies about the identity of the partner clearly makes it rape, and lies about the nature of the act clearly makes it rape. Lies about the purpose of the act should be sexual crime too, maybe not of the same magnitude, but like any non-consensual sex, it should be crime, because knowing the purpose of what you're doing is important. If someone tells me, push the button and the light will come on, but instead the building across the street is blown into pieces, we cannot say that I consented to blowing the building into pieces. I only consented to turning on the light. As for other lies, I would think that lies about STDs and using protection are also criminal, maybe not to the same extent as, say, rape. But these are kinds of sexual battery or just battery and assault, and they also should be prosecuted. Other promises, like promises of marriage and glory and travel, or even promises of the great fun in the bedroom, clearly are not prosecutable, and other lies that have nothing to do with the sexual intimacy probably should not be prosecuted either.
I have to say, Vera, I don't think that it's never, in my case, has going to Yale ever had the effect that you're supposing there. But we'll let that one pass.
Says the Yale graduate.
Another really interesting and controversial issue concerns the status of a transgender person. So we have a number of cases now where a person who is transgender either is being deceitful about his or her cisgender status, or simply doesn't reveal it, and there's a misunderstanding, and his or her partner assumes that the person is not a transgender person. And so the question is whether that should be viewed as the kind of deception that deprives the partner of a sexual autonomy and makes the consent given somehow questionable. It's very controversial because obviously you really have a clash of rights there between the transgender person who wants to preserve his or her privacy and sexual history. At the same time, arguably the partner has a right to have some understanding of what the person's history is. So I think that the courts have really struggled with that, including in Britain in particular, and I think it remains to be seen how those cases will be resolved.
Yeah, and I guess my reaction just reading those cases, it feels like there's a stigma being attached to being transgender, and I think the whole idea of not fully revealing a person's personal history, much less a sexual history. Again, I think you kind of end up in a slippery slope there in terms of whether that should eviscerate the whole idea of consent. So I think that's one of those moral puzzles of criminal law that become very complicated.
And if I may add, because as I said, those were the cases where mostly women were prosecuted, they were not necessarily transgender, because now that we understand more about the nature of sexuality, we don't need to categorize everything. But when we're talking about people who misrepresented their biological gender, and that is probably one of the most difficult questions, as Stuart said when I discussed it while writing my paper. Is it more like lying about your age, or is it more like lying about the nature of the act? The opinions were really very different. And the decisions in the UK are very disturbing, because often people do not necessarily recognize themselves, or do not recognize yet that they may be transgender, or that they may have more complex sexuality. And all three cases that I studied in the that came from the UK involved young women who represent themselves as men and had sex with other women. The latest case is particularly disturbing because the woman was tried and then retried, and both times she was convicted and given very lengthy sentences. She's now in prison for 6.5 years for lying about her sexual biological gender.
What are some of the trends that we're seeing in the United States in the sex as fraud, sex as deception area? Are they moving the direction of Israel and the UK? Are there debates about this across the country? I know that I pulled an op-ed piece in the New York Times talking about sex as deception, so clearly this has generated some discussion in the public policy realm. But are we seeing states move in this direction, and how have they handled that, and are they consulting you guys? Hopefully they are.
Well, it's there isn't quite as much development as you might think. There a number of states have written statutes that are that potentially would allow these kinds of claims, but I don't think we really have much case law yet. The battleground right now is the American Law Institute is revising the sexual assault provisions of the Model Penal Code, which haven't been touched since 1963 when they were originally promulgated. Though I'm not a member of that process or part of that process, I've been following it, and it's interesting to me that the framers or the revisers of the Model Penal Code have actually not taken a particularly aggressive position on this. They've been more aggressive on some other issues, including affirmative consent, at least initially. But they haven't really gone out on a limb to try to broaden the law with respect to these deception cases, and they've mostly stuck to the traditional areas of frauds regarding medical procedures and frauds regarding identity. They've broadened it beyond just the spousal impersonation to include, say, the impersonation of a lover or an intimate. But they haven't gone beyond that. So somebody who misrepresents his intentions regarding getting married or having a long-term relationship, I don't think that would be covered under the proposals, which haven't yet been finalized, but are sort of moving towards finalization in the American Law Institute, which is one of the most influential sources of law and can be counted on to be adopted by states in the years that follow.
And just for our non-attorney listeners, can you talk briefly about the Model Penal Code and what that is?
Starting in the 1950s, the American Law Institute, which was this elite organization of judges and practitioners and law professors, decided that they would try to rationalize American law. You had 50 different jurisdictions with 50 different laws that were sort of all over the map. And they tried to create a more coherent and more consistent body of law, which they call the Model Penal Code, and promulgated it in 1963. Provisions of that have been adopted to one degree or another among many states, including in New Jersey. We have a pretty heavily criminal code that's heavily influenced by the Model Penal Code. So it's been very influential. And about 6 or 7, 8 years ago, it was decided that it was finally time, if there was any part of the Model Penal Code that needed revision, it was probably the sexual offenses. They really were looking pretty threadbare and old-fashioned. So they decided to try to revise them, and I think the process has taken much longer than anybody thought and has been more contentious than anybody thought. And the main reporters, the sort of top people on the ALI committee have been, I guess, are on the progressive side in the sense that they want to broaden the sexual assault laws quite significantly, but there's been a lot of resistance to that among some of the public defenders who are involved in the process and some academics who are skeptical about being overly ambitious and sort of getting too far ahead of where the public is with respect to these sexual assault provisions.
So when does the book come out?
My book comes out in February of 2020, so it's just about going through the copy editing process now, and it'll hit the bookshelves or hit the bookstores. Do we still have bookstores? If we did, it'll be there. You can get it on Amazon, and Yeah.
You must be pretty excited.
I'm excited. I'll be happy when it's finally done. I still have a lot to do in the way of finishing the production process, but yeah, it's good. Happy about it.
And Professor Bergelson, what are you working on these days?
Well, right now I'm working on 3 papers.
Okay.
One actually still has to do with consent. I was asked to participate in a collective project with my European colleagues that involves the different meaning of consent in different contexts, something that we touched upon. And specifically, it would involve the new sexual conduct codes that are now being adopted on campuses, whether they should differ from criminal law, to what extent, how the meaning of consent should be viewed in that context. Another project involves the law of provocation here in this country and in UK, because they are now celebrating 10 years since the big statutory change of this provision.
What is the law of provocation? Just for listeners.
Usually when someone commits homicide under some severe provocation or in under specific circumstances, we treat that as a mitigating factor and we prosecute the individual not for murder but for manslaughter. And traditionally those circumstances involved something like mutual battery or discovery of spousal infidelity or maybe false imprisonment, situations that, in other words, are so emotionally powerful that they even a reasonable person may lose control of his emotions, her emotions, and commit homicide. So that's it. It has been under revision in many countries, including this country, and it would be interesting to see how different attempts to revise that law succeeded or failed here or there. And finally, the last paper that I'm working on would be probably about the meaning of malice. That's a common law term which basically has been abandoned and criticized as being too vague and unclear. So I want to explore whether it still has some importance and whether we want to learn something from that concept.
Can you describe when and where malice is used? And why it's been abandoned?
We usually think about crimes that are intentional as having malice. So, for instance, intentional homicide, premeditated homicide would be malicious, right? But if it was not done with this premeditation, if it was done on the spur of the moment, if it was sometimes provoked for other reasons, if it lacks this particular intentional flavor, then we would say that it was not malicious. And the reason I wanted to look into that, because the Model Penal Code, which has been very influential, it reduced the number of mental states, the culpable mental states, to 4, which was hugely important. Before that, the number, the map of those mental states was vague and clear and involved flowery language, which really no one understood. But at the same time, when you reduce something to those 4 categories, you inevitably lose something. And there have been voices that perhaps we lost something important, that perhaps motive that is part of the culpability, or should be part of culpability, should be still considered. In other words, an offender who kills an innocent victim because he or she wants to rob that person is as guilty as someone who commits compassionate killing of a terminally ill person on their own bequest. And we all intuitively understand that those 2 acts are not identical, that the first one probably should be viewed as malicious, but the second one probably should be viewed as something else, and accordingly punishments should be different. As far as today, very often they would be identical.
What are the 4 categories?
The 4 categories of mental states are purpose, knowledge, recklessness, and negligence.
Okay, so you've done, Professor Green, you've done theft, white-collar crime, sex crimes. What's next for you after your vacation?
Well, I would like to write a book on homicide, so maybe Vera and I can continue working in parallel if Vera keeps going on with some of the mental states in relation to homicide. I mean, homicide is a really rich area. You have questions about the beginning of life and the end of life. You have questions about how do you grade various homicide offenses, as Vera was referring to, and you have questions about the defenses to homicide, justifications and excuses for homicide, which I've written about a little bit before. So that's one possibility, but I'm not going to jump into it right away. I'm going to try to wait and see and think about whether I really have something original and important to say about it, which is, we'll see.
In the meantime, read Dostoevsky?
In the meantime, yeah, I've got a lot of reading and even have a possible completely non-law related book that I might want to write, but I'm not going to say anything more about that.
Oh, come on. Vera, can you get him in? Any final thoughts for our listeners out there?
Well, I think we're all very lucky to be here at Rutgers Law.
And I think Rutgers Law is very lucky to have both of you. We're very, very fortunate.
Can I just put in a plug for, we really do have a strong criminal law program here. We have a certificate in criminal law, we have a strong faculty, we have a school of criminal justice that's in the same building that we're in, and it's a good place to come and study criminal law.
Yeah, talk about the certificate program. I think you were central in its development, correct?
I think both Vera and I were, and it's program that allows our JD students to take a certain number of requisite courses. Some of them are required, others are elective. They have to accumulate a certain number of credits, and at the end of their 3 years when they graduate, they will get the certificate. And I think when they go out on the job market and they're looking for jobs as prosecutors or defense attorneys, my impression is that it gives them a little bit of a leg up. And it's a good place for them to focus their studies. Those who have decided that that's a particular area of interest for them.
Do you want to talk about some of the other faculty members here? Of course, Professor Thomas is extremely well known, and he wrote, I think, one of the major criminal law textbooks. You want to talk about Professor Thomas and some of the other professors working in the criminal law field?
Sure, we have several faculty who specialize in criminal law and procedure. And Professor Thomas and I, at this point, co-chair the criminal certificate program. Professor Thomas co-authored probably the most influential criminal procedure book in this country, together with Professor Dressler, who recently retired from Ohio State. Professor Adil Haq specializes in criminal law and also in the international criminal law and in the law of war. We have Professor Contessa, who teaches criminal law, and he mainly specializes in the issues of international law with some aspects of criminal law. And we have our colleagues in Camden, who also teach criminal law and criminal procedure. So we have a very significant number of both theoretical courses, practical courses, and of course clinics. And anyone who is interested in criminal law will find numerous fascinating classes and seminars and clinics at Rutgers.
Fantastic. Thank you both for being here.
Thank you.
Thank you
for having us.
It was a pleasure.
The Power of Attorney is produced by Rutgers Law School, offering a world-class, diverse faculty of passionate teachers and scholars and an alumni network more than 20,000 members strong around the globe. Rutgers Law has an extensive reach in the legal community. Learn more about our close-knit law school communities in Camden and Newark by visiting law.rutgers.edu.